From the WATE.com Digital Center, answering your legal questions. This is Ask Isaacs. Now, here's Lori Tucker and attorney Greg Isaacs.
Hi there. I think we're going to have to change that open to include Jeff McClain, who is our executive producer, and back by popular demand. We had a lot of people say, you know what, we really enjoyed the segment last week when we were talking about the NIL and your contributions to that discussion. And for those of you who don't know, and we'll get to Greg Isaacs in a moment. For those of you who don't know, Jeff produces our Ask Isaac segment and a whole lot of other programs here as well. So it's a good fit, I think, for you to be here because you are the brains behind this operation.
Well, thank you. I'm happy to help, and I'm glad to contribute. So.
Okay, here we go. All right, so Greg, it's always good to see you.
It's good to see you, Jeff. That's why we all look so good because he's the Wizard of Oz behind the curtain.
He really is. So I'm glad we have this platform to be able to share with you kind of what goes into why we cover what we do. And this is a really important topic because it could be a precedent-setting case, perhaps. A Michigan jury holding a mom partly responsible for a school shooting. Jennifer Crumbley is a mom, like I said, did not fire the shots. Her son did, but she was found guilty yesterday of 4 counts of involuntary manslaughter. So what does this mean going forward?
Well, you know what it means, and I remember covering Ethan Crumbley's trial on Court TV, and the facts just really screamed about the parents' lack of care and common sense as it related to this child. And, you know, let's rewind. In Oxford, Michigan, Ethan Crumbley was a very emotionally troubled young man. And he had cried out for help. And when I say cried out for help, I don't mean that metaphorically. I mean literally. They found notes that he would make at school that says, "No one will help me. I am sick." And
I've asked my parents, they won't do anything.
And he would Google school shootings. This was like days before the shooting. And on that same day, Jeff, as you know, they called the parents. Parents came to school, and the school said, "You need to get this child some mental health treatment. We've arranged it for you." They went home, left him unsupervised, and the rest is an unfortunate history. But the case is very complex, and what the prosecutors did within days is charge the Crumbleys with involuntary manslaughter, which under Michigan law means basically you are grossly negligent. So, you know, I think as we talk about this case, this is a precedent-setting case. Parents liable for a child's conduct, a minor's conduct. But again, it would be rare to find facts this extreme. The parents bought the gun, stored it in a
pretty much put it in his hand.
Yeah.
And the gun safe, the code, they didn't even set it, was 0000. So, you know, that's kind of the backdrop on this. But involuntary manslaughter in Michigan law, 15 years. Times 4.
And now the husband is going to go through the same process.
I'm interested, Greg, to get what your take is on that Michigan law specifically, because at least the precedent here seems to be pretty broad in terms of a parent's responsibility to protect the public from their child. That could go a very, very long way.
On different cases that don't necessarily involve guns.
Or who knows?
Well, think about this. There are two analogies that come to mind. If I have a dangerous dog, let's just say I have a pit bull that's predatory that had bitten somebody, I couldn't leave it untethered by daycare. I mean, it would be something that I think would rise to the level of criminally negligent homicide, reckless homicide, because you substantially ignore a material risk. So, you know, that's something that I think is going to resonate with prosecutors throughout the country, holding parents responsible for minors' conduct. Now, having said that, we, the law, the royal we, have been very hesitant in having parents be vicariously liable for the conduct of children, or I think we'd all be in trouble from time to time. And Jeff, you're going to learn that lesson hopefully one day soon.
Yeah.
But here's the thing: an analogy. I literally just got off the phone with a prosecutor, mentioned what we were talking about, And she said, well, I disagree. And it shocked me. I said, why? These parents disregarded the cry for help, put the guns in the hands of the juvenile. What do you disagree? And she said, what's the difference in knowing your child has a substance abuse issue and you don't take the keys to the car? A gun's a dangerous weapon, and an automobile's a dangerous weapon. Where do you draw the line?
And that's I think maybe what might wind up being the most important factor here is that there's so many. Whether a case in the future goes to trial or goes to a conviction, it seems like prosecutors at least could potentially use this precedent as leverage against a parent. If a child is found responsible or has done something wrong, just the prospect of, well, Mom, you didn't do enough to stop them,
But isn't this more than not doing enough? This is, oh, look, Merry Christmas. We know you have some mental problems.
And that the edge case is always going to be where it's tested is, okay, this was a gun, what about a knife? This was a gun, what about a car? Or this was my child, but I don't have custody of it. Or this was my child, but they were influenced by gang members in their neighborhood. I just think there's so many different variables out there.
This is a good example of, you have civil liability, which means you're negligent. You breach a duty of care. You're not reasonable. Then you have criminal culpability, where you always have to have mens rea, a culpable mental state. But these crimes, this Michigan statute and Tennessee's criminally negligent homicide, reckless homicide, they're intent oriented and driven, but it's a negligence crime. You are so negligent it rises to the level of gross negligence. You intentionally disregard a substantial risk. But where do you draw the line between suing the Crumbley civilly for giving the gun to a child with mental health issues to making it criminal? So that's what this case is so dangerous, is it blurs the line between civil liability and criminal responsibility. And once you open Pandora's box, as we've seen and we've said time after time, it's hard to shut that lid back. So, Jeff, as you said, I can think of a myriad of scenarios where a prosecutor sees a high-profile case and they say, hey, if we can do it in Oxford, Michigan, we can do it in Knoxville, Tennessee.
I wanted also to bring up another component of the conviction here, and it has to do with mental health, because the boy specifically said, "I need mental health care. I have not been given mental health care." If you're a defense attorney, could you not say, "Well, we simply don't have access to mental health care"? I mean, that's a great broad problem across the country, or we can't afford it, or it's not enough, or my child saw a school psychologist.
And we thought that was enough.
Right.
Yeah.
Well, there are just so many things that the facts are so extreme in the Crumbley case. They as you said, Lori, and you weren't being speaking figuratively, literally, they handed him the gun, Merry Christmas. He asked for help, they refused. The school on the day of the shooting said, he is a danger to himself or others, you need to act now, and they ignored it. So just a very series of extreme events.
And having said that, I'm curious, and I know you'll explain it, but involuntary manslaughter, some people online said they were surprised it wasn't a tougher charge against these parents, given everything we know about this case. So explain involuntary manslaughter and how they arrived at that.
We have 5 degrees of homicide. First-degree murder or homicide is an intentional, knowing, premeditated act which requires planning. On the bottom of the spectrum is reckless homicide, where you intentionally disregard a substantial risk of serious bodily injury or death, or criminally negligent homicide. You're towing somebody behind your boat at 120 miles an hour in a heavy trafficked lake. So for negligence to morph into criminal liability, it has to be extreme. So I don't think that the prosecutors could have pushed any more, because again, they're being prosecuted for doing something that typically we see people being punished monetarily. But again, substitute car for gun, mental health for addiction problem. And the scenarios are limitless where parents that do not use reasonable care in a severe situation. And think about this. Now let's talk about how serious this is. And typically the courtrooms mirror problems we have in society. In Tennessee for the last 3 years, more children have been killed in shootings by guns than they have by automobiles. 25 states have mandatory gun storage laws. We do not. So, this, if I was John Q. Public and I learned of this decision, the first thing I would do is make sure, and I had young children, all of my guns are secured, safe, out of the reach, locked up, because not only now can the government come at your pocketbook, they can come at your freedom.
Well, I'm glad you brought that up, Greg. One, there is Michaela's, and we've reported on this, an effort to create Michaela's Law here in Tennessee, which is a safe storage law. It's not the only safe storage law that's been proposed. Safe storage has been a huge topic since the Covenant school shooting.
This is a bill that adds to the present law.
This would add to that. But I want to see, how does this, it seems to run counter to what we're seeing in other firearm legislation around the country, specifically from the Supreme Court. The Supreme Court landmark decision 2 years ago, where the court essentially said that you can't have a law regarding guns that wouldn't have passed muster in 1791. That our gun laws are such a fundamental part of what have you. Could Second Amendment proponents say, well, listen, you can't, our founding fathers didn't imagine a world where everybody had to have a gun safe to have a gun.
But see, I think Crumbley really, you don't want to get bogged down in the Second Amendment, because let's say you got a child that is a pyromaniac that's fixated with blast and fires and that stuff, and you give him a box of matches and say, go out there and outside and have fun,
Go
and
play.
he burns down an apartment complex. Under the Crumbley rationale, absolutely no difference. No Second Amendment issue. It's the parents being grossly negligent.
We're almost out of time, but will this indeed set a precedent? Is this the new way that we're going to hold people accountable for these terrible tragedies that happen in our schools and elsewhere?
Lori, I think it's kind of the butterfly effect. If a butterfly flaps its wings in Hawaii, how far does the consequences go? I think you're going to see two things on both ends of the spectrum. I think prosecutors are going to go after parents criminally more than they used to. That was typically a bright line they didn't cross. And second, I think it's going to cause parents to be more vigilant and responsible. And at the end of the day, if it makes parents parent, it may be a good thing.
All right, we'll end it on that note. Jeff, we're so glad you're with us.
Thank you.
We appreciate everything you add to this
Ask
discussion.
McLean.
Hey, I appreciate it.
Ask
Thank you.
McLean, I
Thank you.
like that. Greg, as always, thank you, and let's
Thank you
talk
very
more
much.
about this at 5:30.
Yeah.
Let's do.
See
All
you
right,
then.
thanks everybody.